grateful for the invitation to speak as an outsider at this conference. The invitation stimulated me to read the Global Refugee Compact. I paid more attention to the Migration Compact before this invitation, and it also stimulated me to look back at my own experience as a practicing lawyer in Amsterdam in the early 1970s with immigrant workers from Italy and Turkey among my clients, and a Portuguese worker who came to the Netherlands in order to avoid military service in the colonies in Africa. His protection needs hidden behind his status as a worker. Now, if you look at the two compacts, and I think one of the interesting things of your project is that it covers both. You see that both of the compacts are primarily political documents with standards on the treatment of category of migrants negotiated between states, coached by international organizations. The two compacts vary considerably. The Refugee Compact is more about relations between states, burden sharing and money than the Migration Compact. This difference has effects at the national level. For instance, in the Netherlands, the Minister of Development Aid at the Ministry of Foreign Affairs is responsible for the Refugee Compact. And the Secretary of State for Justice, responsible for immigration, answers questions in Parliament about the Migration Compact. As a result of this different competences at the national level, the chapter on treatment of refugees in the Refugee Compact, entitled Areas in Need of Support, may well get attention primarily with regard to refugees elsewhere in the world, while refugees in the Netherlands would less or not at all profit from that compact. The two compacts are distinct but related. They were negotiated at the same time and adopted by the same body, the UN General Assembly. The critical opposition by nationalist parties before and after their adoption was directed primarily at the Migration Compact, but also concerned the Refugee Compact. That compact, the Refugee Compact, received more explicit support from mainstream parties in the Dutch Parliament than the Migration Compact, especially the paragraphs on reception in the region, relocation and return, all about migration to elsewhere in the world, were applauded in the Parliament. Now, how are soft law and hard law in this field implemented? For a study of the implementation of the two compacts, the experience with the implementation of hard and soft international law on migration and asylum may be relevant. When I started to practice law, legally binding hard international law on migrants was often not taken seriously by immigration authorities and courts if it would oblige changing national immigration law or practice. The European Convention of Human Rights in those years, if lawyers and civil servants were aware of its existence, was generally considered not to apply in immigration and asylum cases. Hence, there was no need to look for the decisions of the European Commission on Human Rights, available in a few law libraries and only in English and French. Lawyers generally prefer texts in their own national language. So in the Netherlands they were hardly ever read by practicing lawyers and judges. The Netherlands, to give you another example, quickly ratified the 1949 ILO Migrant Workers Convention, hoping to protect Dutch immigrants in Australia, Brazil and Canada, but the convention was held to be not applicable to Turkish and Moroccan workers in the Netherlands. And Council of Europe treaties on migrants and the bilateral recruitment treaties generally were interpreted by the administration and courts in Belgium, Germany and the Netherlands as not granting more rights to migrants than already available under national law, or not granting rights which could be invoked before a national court. Thus, many hard international law instruments or rules on refugees and migrants in practice were transformed into soft law at that time. Until the late 1970s, the Dutch Immigration Act blocked judicial review of most decisions on admission of refugees. This approach changed only after the two European courts started to take the EC law on free movement and the European Convention on Human Rights seriously in the mid-1980s. Only after legally binding international law on migrants and refugees was taken gradually more serious at the national level, questions arose about the role of international soft law, supplementing and assisting in the interpretation of hard law instruments. The UNHCR's handbook and the EXCOM conclusions on international protections both are important examples of soft law instruments gradually getting more status and influence at the national level. The first edition of the UNHCR's handbook was adopted in 1979. It took 7 years before the highest administrative court in the Netherlands for the first time explicitly accepted an interpretation formulated in the handbook. 2 years later, the same court openly disagreed with another position advanced in the handbook. The European Court of Human Rights, already more than a decade, refers to the handbook as a relevant source for the interpretation of the Refugee Convention. The EU Court of Justice followed this example in 2018, several years after their own Advocates General started to refer to the handbook in their opinion. Several clauses in the EU Asylum Procedures Directive codify UNHCR soft law standards. Possibly the most far-reaching example of soft international refugee law becoming hard law at the regional and national level is the recommendation on family reunification in the final act of the Conference on the Refugee Convention. In the Refugee Convention itself, there's not a single word about family reunification of refugees. According to the UNHCR, this recommendation is observed by the majority of states. The recommendation was codified in the 2003 EU Directive on the Right of Family Reunification and thus became binding law in 25 member states. In several states, administrative hurdles still postpone family reunification for years in practice. From my own experience with international soft law in this field at the bar and later at the university, I draw 6 lessons which could be relevant for the implementation of the two compacts and maybe could be relevant for your project as well. The first lesson is that the availability of the relevant text is essential. As long as the text is not readily accessible for NGOs, immigration lawyers and courts, they will not refer to it in their lobbying activities, in their pleadings or in their judgments. I cannot think of a single example where immigration authorities or politicians took the initiative to implement international soft law in this field, where this required changing national law or practice. It was always an uphill battle against a steadfast defense of national law. Publicity is all the more important because soft law does not require ratification and related discussion in the parliaments, and it is hardly ever published in the official journals. In many states, this also applies to the two compacts. Thus, the debate in Parliament, the media, and in the legal profession has to be organized by interested parties. Availability of the text is a first step. Here a problem with the two compacts becomes visible. Both are long texts, formulated and structured rather as political documents than as legal documents. This is unattractive for lawyers, judges and politicians. Any action on implementation will have to start with selecting the issues from the compacts relevant in the country or the region concerned and explaining their meaning and additional contribution in relation to the existing law and practices. The second lesson is that any implementation strategy will have to choose at whom the activities are directed. The general public, NGOs, lawyers, courts, academic, immigration authorities, politicians, the government, or the legislature. Only informing the general public will produce relatively little effects. Specialized national NGOs will be better able to target information and stimulate local mobilization. Some judges may be convinced to interpret vaguely worded clauses in national law or clauses granting discretion to immigration authorities in a way advocated in soft law. But this will require extensive and repeated preparation of arguments by lawyers. References to the 1977 EXCOM conclusions, number 8, and the 1981 recommendation of the Council of Europe Committee of Ministers in test cases before national courts against the expulsion of asylum seekers pending the asylum procedure or judicial review, combined with pressure from the European Commission for Human Rights, in the end resulted in the recognition of the suspensive effect in national and EU law. Courts surely will not be prepared to overrule national law on the basis of political documents such as the compacts. Members of Parliament will generally be inclined to refer to soft law as in the compacts if it supports their position, or on the other hand, as a proposition they think should be rejected. In democratic states, courts and political bodies are separate institutions. Nevertheless, activities in political bodies will have their influence in the courts, and vice versa. In states where the General Migration Compact became subject of open dispute in Parliament, judges probably will be more reluctant to take that compact and its sister compact, the Refugee Compact, into account. The reaction to the compacts varied considerably between governments. At the one hand, withdrawal from the negotiations, abstention or not voting in the General Assembly, emphasizing that the compacts do not create legal obligations, absence of political debate at all, or on the other hand, explicit positive evaluation and support of the compacts. Thus, it would be interesting to study comparatively to what extent the political reception of the compacts influenced the actions and positions of other actors in the country concerned. Moreover, these positive interactions point to the need to think strategically about the time sequence in which order are national or local institutions mobilized, or are they all mobilized at the same time? The third lesson is that court procedures, both on international hard and soft law, even when the case is lost in court, may produce interesting side effects. It may result in media attention, illustrating the issue, and mobilize public or political support. These effects could be illustrated with the cases in Spain and the Netherlands on the insufficient implementation by member states of the two EU regulations of 2015 on the reallocation of refugees from Greece and Italy. Both test cases, which landed the one before the Spanish Supreme Tribunal and the other before the Court of Appeal in The Hague, were lost. But the Dutch case drew a lot of media attention for the moderate size of the Dutch contribution in relocation generally. The fourth lesson is the essential role of institutions monitoring the implementation of international documents. The effects of such documents are closely related to whether those bodies are dealing with individual cases. Often, such bodies became gradually visible for public opinion only after they started to deal with and issue opinions in individual cases, or when such bodies started to inspect specific reception centers, detention centers, or expulsion activities of states. This applies to the UN monitoring bodies such as the Human Rights Committee, the CERT, the Commission Against Torture, but also to the European Commission on Social Rights and the European Committee on the Prevention of Torture. Here, the difference between the two compacts is clear, with the central role for the UNHCR in the review of the Refugee Compact and a rather complicated and multi-layered review process of the Migration Compact, with a far less central role for the IOM. If the review of the Refugee Compact becomes essentially a discussion between state representatives in the biannual meetings of the high-level officials or the 4-yearly forum and in the UN General Assembly, this may considerably reduce the effects of this compact. The fifth lesson is that implementation of international standards is a long-term process, requiring many years and a long-term perspective. The established national refugee organizations could play an important role in monitoring and supporting the implementation. My informed guess would be that in many states, immigrants organizations are far less established than refugee organizations and often too underfunded to perform a similar role with regard to the Migration Compact. The IOM tradition of project-based financing will not be very helpful at this point. The long duration of this process also creates problems for research as your project on the implementation already so soon after the adoption of the compacts. My sixth and final lesson is, do not forget the role of academics in the implementation project. Academics as researchers, providers of reliable information, and lobbyists linking between different groups and levels of society. So look at yourself and your activities and those of your colleagues. Thank you for your attention.